Good afternoon, everyone. Well, not bad, not bad. Hearty souls here. After a long day, now we're here around 4 o'clock and you're all here. That's great to see. As many of us know from experience, data supporting or refuting claims regarding the business of the courts is absolutely essential. Whether the issue at hand is one of case flow or fiscal in nature, statistics tell a compelling story to our stakeholders, perhaps better than we can explain in detail. In order for data to support our positions, we must frame the statistics in an easily comprehensible and legible presentation to our audience, our stakeholders. Although there are several types of, or several styles of presentation, they may be successful in proving your point. We have found that a presentation such as the one you're about to view and discuss today to be successful in the ability to transmit the desired message to our target audience. This presentation is called dashboards. And certainly technology plays a key role as well in not only in the development of the presentation, but also ensuring the ease of capturing what we want to measure and how these measurements are then presented. Here to discuss the development and the use of these dashboards is the director of our Research and Statistics Department from the Administrative Office of Pennsylvania Courts, Dr. Kim Nieves. And Kim's bio is posted, and you have your materials there. I'm not going to go into great detail about her bio other than to say that she's been a wonderful director of our statistics. She's been in our department for over 14 years and has been in the director for this position in the last six years. So without further ado, I turn it over to Kim Nieves to present to you on dashboards use in Pennsylvania. Thank you.
Hi. I know I'm the only thing standing between you and cocktail hour. I get it. So we are going to make this as painless as possible. Thank you so much for coming. That's kind of what I'm going to talk about, sort of. Dashboards are certainly a modality that we have been using to present our data. We have found that we actually use Tableau. So if you were in the last session, another vote for Tableau. But more than that, there's a lot of ways to tell stories. We can tell stories with language, of course. We can tell stories in movies. We can tell stories in theater and music, and we can tell stories with data. I know, you're thinking she started drinking already, didn't she? No. I am going to convince you that data is a language. It is a language that you can compose to tell the story of your courts. So this is how we're going to begin, and this is how we're going to end. Data are not math. Before you leave here, you will be convinced that they are not math. They are numbers that can be deployed to applied statistics and boring and one-dimensional things such as that. But they are actually language. I'm a little off, so I'll read to you, which I hate to do. Data are language promoting communication and shared vision. Data provoke action. Those are the three things that you need your data to look like. And if your data doesn't look like that, throw it away. Find different data. Use it differently. I'm going to tell you today 2 data stories. A story that promotes communication and shared vision, that data had that, and where data provoked action. So are you ready? A little bit first about what the kind of data we have in Pennsylvania, the language that we have. I think all states now are at some point of planning, developing, implementing, refining an automated data system, correct? Everybody's got automated data. Everybody's dreaming about automated data. Everybody's drowning in automated data, correct? We are actually doing all 4 of those things. We are planning, we are refining, we are implementing, because we're half and half. Our criminal, dependency, delinquency, and lower court are on a statewide case management program. It is automated and as uniform as humanly possible. What does that mean? That means we don't need to have the districts report their caseload data to us. We can just reach down and grab it right directly out of the system. It's uniform, we can clean it for you, we can verify it for you, and everybody's data looks the same. On the other side, civil family jury, PFA, and orphans court, which is like our probate court, they're still manual systems. Now, it doesn't mean somebody's going through a file cabinet and counting colored tabs. What it means is These are on different vendor systems that are supported by the districts themselves. So guess what? The language now has 60 different dialects because we have 60 different districts. So trying to get uniformity off of this side is a little bit more challenging, although if I do say so myself, we do a darn good job at it. So that's the kind of data systems that we're dealing with. We have all the problems and pleasures of automated data, and we have all the problems and pleasures of manual data systems. So let me tell you a manual data story. Remember I said we have to work really hard to get all of these different dialects of our data language to become uniform and translatable and interpretable. So one of the things we did in our manual side with our civil is we implemented a civil cover sheet. We implemented it by procedural rule, so every filing now must come with this statewide cover sheet, no matter what district you're filing in. A little bit of background. Before we started this, we had terrible civil data. It was awful. The National Center wouldn't even publish it, if I recall properly, because we did this wacky thing. We would count the case. We had the districts count the case upon docketing, and then we didn't care about it at all. Didn't look at how old it was, didn't look at what case type it was, until it became something ridiculously termed trial ready. Anyone know what trial ready means? See, our data were terrible. You couldn't even understand them. So trial ready was basically when the attorneys completed discovery, then put the case at issue and declared to the court it was ready for trial, then we would count it. It may have been docketed 7 years ago, but darn it, you docketed it last month, so we're calling it a month old. So we didn't know how many cases we had in the active inventory. We didn't know what kinds they were. We didn't know exactly what the dispositions were, because most of those cases settle, right? They don't even get to trial ready. So by my estimation, we were probably accounting for about 15% of the civil litigation in our state, which was ridiculous. So we tried to get everybody's dialect back into a little bit of a more uniform reporting system so we could be more accurate. Now we have accurate documentation of our civil cases. Wah! Oh, crap. Lo and behold, be careful what you wish for, we found a tremendous volume of pending cases out there, far more than we could have anticipated. And they were a lot older than we possibly thought they could be. We're accurate. We're not happy and we're a little embarrassed, but we're accurate. Our Chief Justice at the time was alarmed. So he sent a letter to each of the districts saying, look, what percentage, why are your cases so old? And what are you going to do about them? Here's your task. If you choose to accept it. No, it was not an if you choose to accept it. It was do it and do it by the end of the year. It's nice to have the Chief Justice send that letter out. So they were to go after the oldest cases, find out if they're still active. Maybe they're just dormant and sitting there on the docket. Clean them out through some termination or administrative purge, and also tell us what you're going to do to make sure it doesn't happen again. Put in place a case management plan, a civil case management plan. Now remember, this is kind of our fault as an oversight agency, because for all those years we were only counting trial-ready cases. Once you docketed it, you didn't have to report it to the oversight agency, us, the AOC. We didn't care. So why would they care on the ground? Why would that be important to them? The data reflected the value system of our oversight agency, and so this judicial culture of hands-off, pre-processing a case before it was ready for trial, kind of took hold and crystallized. So undoing decades of that was really what we were trying to do with this new initiative. So we asked them why their cases were too old, and the news was good. Most of them said, it's our vendor system. It pops cases back into active status if there's post-trial activity. It won't close a case until a judgment is satisfied. So there were weird and wacky things that the vendors, the systems out of our control, were doing. That's good news. That's technical. That's not laziness. That's not slow. That's not lack of resources. That's just an artifact. We can fix that. And the other was, we don't have time or money to purge cases the way you want us to do it. We have a procedural rule governing the administrative purge of civil cases, and according to them, it was absolutely impossible to keep up with, so they just didn't do it. That's good news. We can fix that. We can make that easier for you. So here we have two low-hanging solutions to fix it. The rest of it was, we have no control over the attorneys, and there's nothing we can do until those cases are trial ready. That we can't necessarily fix, but I'll show you. We made some inroads. So we went about fixing these items up front. We rewrote the procedural rule and simplified it so that purging was possible and you could take out those dormant cases. Well, I didn't get in my car. My associate Lori Soccerdoty got in her car and traveled across the state and met with all of these vendors so that we get proper data definitions and proper dispositions on these cases. That was easy. People did incredible things, heroic efforts to get their notifications out. They sent out batch notifications to parties that they were going to terminate the cases unless they had notified the court that they intended to proceed. I don't know if you can read this, it cracks me up though. So the Montgomery Court of Common Pleas is ramping up efforts to clear out a backlog of cases dating as far back as 1980. And in the coming months, the court will put more than 100 languishing cases on an expedited case management schedule that would entail putting attorneys on 48-hour trial notice. Dang. The first thing I thought of is if you filed that case in 1980, you are not young and spry enough to respond to a 48-hour trial notice. You've aged. Anywho, 35,000 cases, folks, came off the dockets in less than a year, just from these administrative purging. You're not buying it, are you? You're not buying all the headlines? All right, I won't lie. It wasn't really the New York Times. It was more like the Pike County Dispatch. But it was very exciting. From the top of Pennsylvania to the bottom. That's a big deal. That's a big deal. And it all came from judicial leadership, and it all came from paying attention to the data, right? We're not lazy, we're not bad, we just have bad data. Oh yeah, okay, I always stick this in there because it doesn't really go, but I always have to put it in because it's fabulous. So this is Crawford County, which is sort of center. It's more on the rural side. Here's how they handled their cleanup. On March 2nd, they sent out an order for mandatory status conferences for a total of 1,699 cases, all scheduled for April 24th at 8:45 a.m. in courtroom number 1. This was a very entertaining project. It didn't start out that way, but so I know you're wondering, no, as they had anticipated, most of those parties did notify the court. No, we settled a long time ago. This was discontinued ages ago. So I think they had about 320, 350 people come, and they triaged those into status conferences, case management orders, et cetera, et cetera. So they got a handle on it. They went from 1,700, we have no idea, to 300. Now we know how many and what we're going to do. Oh, the next chapter. Remember I told you that the Chief Justice asked, what are you going to do so this doesn't happen again? Well, case management in Pennsylvania for the civil side is very spotty, and let me show you. So on this map, all of those light green districts are categorized as attorney-driven. That's a phrase they use to describe themselves, attorney-driven. So over half have absolutely zero case management practices in place, none. The attorney files, and 7, 8, 9 years later, when it's time to go to trial, they will show up again. There's no pre-case processing that happens. So we have an uphill battle here, but after categorizing all of the districts according to their case management level, so we have attorney-driven, which is 0, and then at the far other end of the spectrum, we have court-controlled. In order to be categorized as court-controlled, you needed to have timelines for discovery, and the case is assigned to a judge upon filing. So those were the two characteristics of a case management program that we call court-controlled. And then there were 2 other levels in between, gradually from no control to more control. So from there, oh, and where you have a star, they responded to the chief, look, we don't have anything now, but we're putting together a local rules committee. We are going to get something together for you. So this is good news. These are all, by the way, on our dashboards. So part of the important part is these data have to be out there. The counties need to be able to go somewhere so they can look at each other and say, oh boy, everybody's adopting case management plans and we don't have one yet. Oh dear, everybody is getting smaller with their age, their volume and age of their inventories, and we're not getting there yet. So check this out. This is one of my favorite things on the planet. Okay, I made it, so I'm a little bit biased. However, this chart is on our dashboard, and it shows, ooh, sorry. I thought I had my pointer in my hand. So at the top, we have some very light green, and these are inventories that are 70, 60, 50% of those cases are over 2 years old. Well, I'll be darned if they're not mostly light green. So what this chart tells me is that those, that those case management systems that are attorney-driven are synonymous with older inventories. I don't know. I just draw the data. I just tell the story. I'm not judging. But it seems to me the popular kids who are dark green are all clustered down here, with much younger inventories. So what we will expect to see is, as more counties adopt case management programs, that they will begin to get darker green and they will begin to float down here. Now the state average is 40%. It's not a great number, it's a little embarrassing, okay, but we're coming back. We are coming back from a long tradition of being kind of hands-off on any of the civil case management. So a word about performance measurement and performance management here. We are not going to tell these counties that they must become court-controlled. We are not going to tell these counties that they need to have their inventories under 20%. Only 20% can be old. We're going to let an organic process take hold here. That's performance measurement. My job is just to draw the picture and to allow the stakeholders to decide what's appropriate for them. Now, when we asked for those case management, we had a couple of president judges that wrote to us and said, we are attorney-driven. We've always been attorney-driven. I like it attorney-driven. Thank you. That was their case management plan. That was their response. Okay. But that's okay, because if that works for them and they're happy at the top of this chart, then they'll stay there, and they're my control group. That works well. They're going to keep me right, because I'll have a lot of light green up here as everybody else starts to shrink here. Is there something else I wanted to say about that? I think so, but I forgot. So it'll come to me if it's important. So now, at the end of this civil inventory project today, and I really mean today, we just finished this update last month, we're down 21% in the inventory. And this is over now 3 years. So you expect a little bit of an uptick, right, with population and filings? No, we are going down. And there's all of these cleanup efforts are ongoing. So we will continue to go down. Not less than 16 districts have implemented local rules for civil case management, whereas they did not have those before. So we're down 16% on the statewide inventory age. All of this came from the data. The data not only tells the story, it drives the story. And we still have on our dashboard, okay, let's see if this works. Oh, it's not going to. We still have on our dashboard, we update the maps and we update the charts every 6 months. So the counties can go back in and see how they're doing. They can see the effects of the changes that they have made. And I really insist that that would work. So we will be able to track going forward every aspect of the effects of their changes. So it's not just the changes for them, it's the changes for us. So here we have the original map, and it is light green. Look where we are today. Got a lot darker, didn't it? 16 new counties. Now we have our bar chart, which still originally had the light green up at the top. Now today we have those 16 counties that have adopted new case management systems. So even though they're at the top now, we expect, if my hypothesis is correct, that they will start coming down to the bottom of that chart. Okay, so that's story number one. That's data that we had, that's data that we directed, that's data that we used to tell a data story. I got another one for you. One more data story. This one has to do with protection from abuse, and this one really had legs of its own. I had nothing to do with it. I love this. So, This is our protection from abuse dashboard. Again, all of these are online, and we don't design these on our own. When we designed the PFA dashboard, we had a work group of domestic violence advocates, of law enforcement, lobbyists, lots of folks around the state involved in the domestic abuse arena to tell us what data they wanted to see. What do they want us to keep track of? What do they want us to post and update? And I'll be darned if they didn't want temporary orders. I didn't really understand the importance of them, but they all agreed we must have temporary orders counted and posted. Cool, I'll do it. So in Pennsylvania, when you go to get a protection from abuse order, you can request a temporary order, which is going to get you through those 10 days before your evidentiary hearing. So they're tough. They're tough because the alleged abuser could lose access to his or her home, his or her children, transportation, and in Pennsylvania, they'll have to surrender their firearms, which the sheriffs, the law enforcement doesn't like this feature of our statute, and neither do the gun owners. So this is a tough one, but it looks like in Pennsylvania, we have decided to err on the side of safety because 88% of those temporary orders are granted. Only 12% are denied. So these data have been up for a number of years. Then I get a call from a reporter in York County. This screen and my dimensions aren't always helping me, but York is right here. We'll call it ORC, just for the sake. So in York County, I get a call from a reporter, and they were doing generally a story. They had some domestic abuse fatalities, and they wanted to do some research as to why that might be in their county. And they went to our website. They saw the temporary orders in their county were way far and above. The denial rate was way far and above what it is. It's only 12% in the state do our judges typically deny temporary orders. In your county, they're denying 44%, which is even higher than their class of county average. So the reporter called me and said, "What's that about?" I said, "I don't interpret the data. I make sure that it's accurate for you, but this is your job. You take the ball from here. Find out and let me know." I turned her back to the county. The county is the expert on their data. We just verified that it's accurate. We saw that. We knew they had a big jump. We gave them a call before we published that data, and they said, "Nope, that's right." And so there it was. So they actually went into the courthouse and decided that they wanted to see what the denial rates were by judge. Oh, good. So here's just for a moment, because this is why a lot of us don't publish our data or publish the possibly controversial data or the data that's going to provoke a reaction. You can't provoke action. Your data isn't going to provoke action if there is no reaction. We have to stop being afraid of the data that doesn't flatter us. We have to stop being afraid of the data that doesn't show that we're perfect. It is hugely important that our assets and our needs, our strengths and our weaknesses are out there for all to see, or there's not going to be any change. Don't be afraid and fight to show all of the data, not just the pretty data. So they went in and they found out, so here in Pennsylvania, there we have that 88% granted rate and that little 12% denied. In New York, there's 44%, there's the granted rate and there's the 44% denied. And here it is by judge. Look at the disparities. So not only are you more likely to not get a temporary order in that county, but it may depend on what judge you get too. So they wrote a really nice article, but the temporary PFAs were the centerpiece. They became the infrastructure of their article. And it was a really good article that provoked a lot of conversation and a lot of follow-up articles. This is one of the follow-up articles, is they asked the judges, "Why are your averages so far and away from the rest of the state?" And the judge's response was, "I don't know what to do with that, because we're supposed to be looking at the facts in front of us. We're not supposed to be looking at stats and trying to, play to the test or play to the benchmark. So it really doesn't make sense, does it?" But the question still needs to be asked, why are those decisions, what metric is being used that is so different from the rest of the state? So they called together a community action group to discuss this. We had the County Bar Association was there, the judges were there, the women's shelter was there, victims were there. The entire domestic violence community got together to discuss this article. I'm going to show you, it is exactly 4 minutes and 30 seconds
Welcome to the
of
Martin Library.
this discussion,
Thank everybody.
and it starts at 28:33. And they discuss how the data provoked some action in this particular instance. I love this. Absolutely love this.
We'll get to you. That's fine. One of the main aspects of Ed and Brandy's story was the New York.
Can we get more volume?
This spread between the percentage of temporary PFAs
Thank you.
granted by judges on the bench. We could talk a little
Even
bit
more?
about how are judges interpreting the law and what kinds of things are they taking into account and the process and procedure. But I'm interested in possibly one of the judges in the audience, or maybe I see Victoria Connor, who was with the New York County Bar Association. Maybe they want to jump in on this, but what kind of training is there in terms of directives for judges? Like, here's the law, here's how you enforce it, here's how you rule on these cases. Is it basically based on an individual's judge's perspective on the situation, or are there more stringent guidelines that they really should be following? And is there a role for the court, for maybe the AOPC, the administrative arm of the Pennsylvania courts, to sort of look at these things, look at the statistics, and say, there's an interesting spread here. What's going on? So, do you folks, first of all, have any perspective on that? Do you think that there needs to be training, or is there some aspect of the law that?
Well, I think it's an interesting question because we're not attorneys, and so we don't interpret the law, and that is a heavy burden, I think, for judges and attorneys to shoulder. And so I don't necessarily know the answer about how things are interpreted and all of that stuff, because that is beyond my level. I do think that judges absolutely take their responsibility seriously, and my finding is that and I've said this a couple of times, so some of you may have heard me say this before, but when we look at a situation in the context of power and control, when we look at a situation in the context of what we know about lethality, that absolutely gives us more information. So would it be a bad thing for folks to take those things into consideration while they interpret the law? And that may not be something that I can answer because that's not my role.
I guess what I would say is I think with the data that's out there now, it begs questions.
Sing, brother.
I think Brandy and Ed's article left every reader, regardless of their level of expertise in this area, with questions. I do think those questions should be answered, but again, I'm not in a place to provide those answers. I imagine the courts will look at that and say, okay, let's understand this for what this is and make sense out of this. And that is my hope, that such an article that has data is kind of entitled to a response as to how do we reconcile this disparity here and what's going on. It's similar. We're accountable to the county as well too, and if there's a discrepancy in our data, I would feel compelled to be able to respond to that. But I do believe the court is looking at that. I don't know for sure, and certainly Judge Adams can respond on that, but I do think there should be some scrutiny as to, okay, why is this? Let's make sense. And maybe the answer is it's this reason and that reason's okay, but I think the article that Brandy and Ed wrote really left that prevailing question is, wait, why is your county different? And why are different judges different? So my hope is that over time we will be able to, have some answers to that, and we will be able to look at this process. And I look at this article really as an opportunity. I hope it's not a blaming as much as it is, okay, here is an issue here. How do we help to improve or look at the PFA process so that it is victim sensitive? That's my goal, so.
So what's important to me, or what I'm trying to communicate there, is all on their own, they're having these meetings. Every member of the community is now talking about these data, what they mean, and not in an accusatory fashion. These data scared the president judge when it came out. My court administrator was a little pissed. But you know what? With the process that has begun here, I guarantee you this county is going to be ahead of the curve in terms of protection from abuse procedure in the coming months and years, because they're talking about it. They're taking their data seriously. They're looking at the story that is told about them through that data, and they want to write their own story going forward. They might want to take that down. We have the granted and denied. We can see at the end of 2014, they started to grant a few more and to deny a few less. And then at the end of 2015, how do you think this story goes? Shut the front door. So, I don't have to say anything about that, right? I don't know if that's good or bad. Frankly, I was a little horrified to see it. But that is the data story, that all of this activity and scrutiny and concern has changed practice. It provoked a reaction, an action. And as a research analyst, it's not my job to follow that action, to monitor it, to evaluate, to track, to measure, to publish, and to make it available. That's what I do. But this story has legs of its own, as does the civil inventory, and it is going to keep going at that pace. And it all started with the data. It started with the right data. I didn't want the temporary orders. I had no intention of publishing them until the community of domestic violence advocates said, please, that's what we need. And it sparked this entire process. So if the data is not doing that, you're not making the best use of your data, or you're using the wrong data. So we're back where we started. Data are not math. Do you believe me? Data are language promoting communication and shared vision. Do you believe me now? Humor me. Yeah. And data must provoke action. You don't have to respond to that because you haven't tried it yet, I assume. But go home and try it. Go home and tell stories. Do you have any questions for me? All right. Go home and tell stories. And I have bling for you up here. I do. Here, I'll give it to you, and you can just go like this if it's worth it that they should come up and get one, okay? Give them a sign. She said it's good. Come on up and get your... Thank you so much for coming out at the end of your day. I appreciate your attention this late in the day, and I'll be around for the rest of the conference.